Hello, everybody. Thank you for joining us today for our webinar, Making Headlines for All the Wrong Reasons, How to Avoid Litigation from Your Investigations. Before we get started, I want to go over a couple of housekeeping items. We are going to take questions throughout the webinar. I expect this webinar to run about 30 to 40 minutes, and then any leftover time that we have, we will use for questions. So please use the question or chat feature throughout the presentation. We'll get all those questions loaded up and then address them at the end in the Q&A portion of the webinar. You will receive a copy of this presentation following the webinar within a few days, along with some additional resources. And as always, we welcome your feedback. So please take a moment to respond to our post-webinar survey. Let us know how we're doing and if we can improve anything for you guys next time around. And there are a number of other webinars coming up, so be sure to check out our website and join us on those future casts. I want to start out telling you a little bit about myself. If you haven't sat in on one of my webinars before, my name is Lowry, and I have worked for Convercent for over 7 years. At Convercent, we provide easy-to-use compliance software that gives you predictive analytics to mitigate not only people risk, but also safeguard your reputation. Convercent serves customers ranging from large corporations to fast-growing small companies with operations in over 130 countries. We are across a variety of different industries. I personally work on the professional services team as a behavioral sciences expert and manage our investigations team. I received my master's degree from University of Denver with the master's in forensic psychology. My area of expertise include conducting corporate investigations on a variety of employee misconduct topics, and I have a particular specialty in conducting threat assessments for workplace violence situations. I also conduct a variety of different trainings. We do some in this format, in the webinar format, and I also conduct live instructor-led trainings on a variety of topics, the process of investigation being one of the most popular topics, and we'll get into that a little bit today further on in the webinar. This webinar was actually prompted by a recent New York Times article in which an employee was interviewed about an alleged false confession and his pending court case. I will be mentioning several court cases that involve specific companies throughout the course of this webinar. I do want to make a quick disclaimer and note that I'm not attempting to single out any one company, rather with reviewing court cases in general, looking for opportunities on how we can improve our process. In preparation for this webinar, I researched many court cases, and the information I'm sharing today is based on facts reported from public record as well as news article interviews. So today, I'm going to talk about some of these recent court cases that have highlighted poor workplace investigation techniques. I'll then review some of the legal definitions that are addressed in those court cases and briefly discuss due process rights and how we can apply those in our corporate workplace investigations. Lastly, I'm going to outline Convercent's approach and best practices for integrated compliance and investigations. So let's go ahead and get started. As I stated earlier, this webinar was prompted by a New York Times article which focused on an interview of a former AutoZone employee, Chris Polston. Chris reported some facts about his particular situation to the New York Times. He reported that he was initially approached by an AutoZone investigator and was asked for assistance in investigating a theft. Chris initially thought that he was just being questioned as a potential witness or someone who could help out the case, and only later discovered that he was actually the subject of the investigation. He explained that he was taken to the store's overstock room and sat down between a cinder block wall and a row of batteries. The investigator began their conversation with making small talk, talking about the joys of fatherhood and some other personal matters. Very quickly, the investigator shifted gears and began accusing Chris of stealing auto parts. The investigator claimed that he actually had a DVD that showed that Chris was stealing auto parts from the store. It's unknown at this time whether or not that DVD exists, but reports suggest that it actually doesn't. Chris was told that he was not allowed to leave the room until he confessed. He was specifically told, if you confess, you will not lose your job or be charged criminally. After 2 hours of intense interviewing, the investigator said he was going to have to call the police because Chris was not participating in the interview. Chris felt he had to acknowledge something, and that would be the only way that would get him out of the room, so he acknowledged that he had previously taken a candy bar and soda from the store. At that time, the investigator concluded the interview, allowed him to leave, and Chris was ultimately terminated for taking that candy bar and soda. Now, it's not uncommon that when conducting a theft investigation, individuals will admit to lesser charges than they were initially confronted with. So that in of itself, that Chris admitted to taking a candy bar versus auto parts, doesn't really suggest that it doesn't suggest either way strongly that he stole the auto parts. However, after that admission, the investigator made the recommendation to go ahead and terminate based on him taking the candy bar and soda. It's been reported in this article that the manager actually said he gave Chris that candy bar and soda, that he was actually fired for stealing. However, the investigator never followed up with the manager, never double-checked those facts, and so in fact, Chris may have been wrongfully terminated. So Chris is currently suing AutoZone and the particular investigator. His claim is that based on the false representations and threatening behavior of the investigator, he was actually coerced into making a false confession. So we don't know where this case is going to turn out quite yet. It'll be interesting to see what side the civil lawsuit comes down on, but we'll find out more in July of this year. It is scheduled for trial down in Houston, so keep your eyes and ears open for that. Chris's case is not the first time AutoZone's investigative practices have gotten them in trouble with the court system. Back in 2006, there's a well-known case of Joaquin Robles who sued AutoZone for false imprisonment and fraud. The details of his case, he was accused, there was about $820 that was missing from a bank deposit. Robles was the last person to make that deposit and was therefore questioned about the missing money. It was thought that he had stolen it. He was questioned for approximately 3 hours, was not permitted a break. He was told by the investigators that he could keep his job if he confessed, otherwise they were going to contact the police to deal with him. Eventually, Robles signed a confession that he did in fact take the $820 and was fired based on that confession. However, 2 weeks later, the money was actually found by the bank. So the bank claimed that the money had been misplaced and it was a mistake. So this proves that Robles did in fact falsely confess to stealing that money. The court agreed that the false imprisonment that was enacted by the investigator and the false statements of leniency made by the investigator coerced Robles into a false confession. As a result of this claim, he was actually awarded over $700,000 in damages for the false imprisonment and fraudulent behavior of the investigator. This is a huge, huge win for that plaintiff. We don't usually see the awards in this amount, but it was so clearly a coerced false confession. The jury actually initially awarded him even more money, but the judge put it down a little to that $700,000 mark. As a result of this Robles case, AutoZone reportedly made revisions to their investigative approach. However, based on the Chris Polson case that we just talked about, as well as this 2010 case that I'm going to talk about, there still remains questions as to the ethical behavior exhibited by some of their investigators. So in 2010, there were these three plaintiffs, Gomez, Santana, and Cortez, who all collectively sued AutoZone on claims of false imprisonment and fraud, very similar to the Robles and Chris Polson case. While all three of their case details differ somewhat, they have similar overlapping complaints about the techniques used during the interviews. So I'm just going to generally outline some of those complaints. The three individuals claimed that the investigators did not conduct an adequate investigation prior to interviewing them. They claimed they were threatened with arrest and made false promises of leniency and continued employment in exchange for a confession. Santana was specifically told that he could not leave the room to pick up his children, and he was not allowed to contact a lawyer. He was told that if he did contact a lawyer or try to leave, the police would be called. In this particular case, the jury found that the investigator did act with malice or fraud when he made false representations in each of the cases involving these three individuals. The jury concluded that the investigator knew the information that they were saying were false and were not intending to follow up with it. Experts even testified in this case that the investigation manual's contents and tactics could potentially cause a coerced confession. Now, ultimately, this case did end up in favor of AutoZone. So while the jury did find that investigators made false representations or false promises that they did not intend to keep, they did not believe that this was a substantial factor in causing harm. So basically what that means is that the lies that were told by the investigator during those interviews in the jurors' eyes did not amount to violations of the law in this particular case. Even though it may not have been a violation of the law, the behavior is still unethical. In this case, it didn't particularly matter because two of these three individuals were actually criminally convicted of theft, and they were believed to have engaged in the behavior. However, in the other cases, when it turned out to be coerced false confessions, it did have a large impact. So just because in this particular case it wasn't a violation, we still do see issues with the techniques that were used. AutoZone is certainly not the only organization that has faced lawsuits related to their investigative techniques. The Firmino versus Fedco case actually set the precedent for false imprisonment claims. So I'm going to spend a quick minute here talking about Firmino and what unraveled in her case. So there was an alleged theft of a $4.95 sale to a customer. Firmino was interrogated in a windowless room by two managers and two security agents for over an hour. When she attempted to leave the room, one of the security guards actually physically slid in front of her and threw up a hand in a gesture for her to stop and stated that she was not allowed to leave the room. Firmino was told that there was both a customer and an employee waiting in the next room that had witnessed the theft and that she better confess to it. She was told that the interrogation could either be handled by her admitting her guilt or they were going to turn it over to the police. All of her requests to leave the room or take a break were denied. Eventually, towards the end of the hour or two interview, she ended up breaking down in tears and became hysterical. At that point in time, management admitted to her that they in fact had nobody waiting to testify against her. They had no witnesses to this alleged theft, and they at that time then stated that they believed her. Firmino was very upset, as you can imagine, with this kind of threatening behavior, and she sued Fedco for false imprisonment that resulted from a method of interrogation that was approved by the company policy. This set the standard definition for false imprisonment, and she was successful in her lawsuit and awarded $175,000 in damages. In addition to the Firmino case that really got everything set off for these types of cases, in 2010, Ruben Cavillo successfully sued Costco for false imprisonment based on the tactics of their internal investigators. Ruben was interrogated regarding an allegation that he deliberately sold expired meat. He was placed in a room with two interrogators. Ruben is more slight in stature, and he described the two interrogators to be extremely large, over 6'4" and around 240 pounds. The small man was placed in an office and felt that he was contained. He believed he was locked inside and not allowed to leave. He was interrogated for multiple hours. He claimed he was specifically told, "You are not to go anywhere. You are staying here until you confess." This interrogation did not end until Ruben was rushed to the hospital for stroke-like symptoms as a result of the stressful interrogation. Ruben then sued Costco successfully for false imprisonment and the emotional distress that he experienced as a result of that interview, and was awarded $102,000 in damages. So as you can see, there are many examples of companies being dinged on this false imprisonment as well as fraud aspect to their techniques of interviewing. So we spent some time talking about these court cases that highlight the certain behaviors. Now let's provide you with some definitions so you can help understand the legal basis of these claims. There are two specific claims that we've mentioned in several of these court cases. false imprisonment, and fraud. So let's dissect these a little bit. The definition of false imprisonment is non-consensual, intentional confinement of a person. Now, this confinement can either be physical, so physically blocking exits and things like that, or it can be some kind of threat of force or threat of arrest if they aren't participating. There is an exception to false imprisonment, so I do want to note that. The exception is for employers are allowed to detain individuals who they believe are about to injure their property. So what that means, if you have an employee that you believe is in the act of stealing property or money, has it on their person or has them in their car and are about to leave the premise, you are allowed to detain them for a reasonable amount of time to ensure that they don't run off with your property. However, if you don't reasonably believe or have probable cause that they are in an act of committing that theft, you cannot detain them, and false imprisonment is going to apply. In the cases that we reviewed, the plaintiffs felt imprisoned for several different reasons. Some of them, it was the number of individuals in the room. If you recall, one of the cases actually had 4 people in there interviewing them to the 1 interviewee. In the Ruben Cavillo-Costco case, his claim of false imprisonment was based on the stature of the individuals. It could be physically blocking the exit, making statements that the subject is not allowed to interview the room or leave the interview room, and even the size or location of the interview room can lead to false imprisonment claims. The other big claim that's been coming up and is much more convoluted is the claim of fraud. So in order to have an effective claim of fraud, a plaintiff has to have a reliance on a representation made by the investigator. Based on that reliance, it has to result in some kind of damage to the plaintiff. And that damage cannot be attributed to the behaviors of the plaintiff. It must in some way be attributed to the behaviors of the defendant, in this case, the company or the investigator. So let's break this out using one of the examples we talked about so we can have a better understanding of what I mean outside of all that legal language. So fraud was most clearly exhibited in the Joaquin Robles case. So he reasonably believed that the false statements made by the investigator that he could keep his job and the threats that the investigator was going to contact the police if he didn't confess. He reasonably believed those statements, so he confessed to an act that he did not commit. Based on the fact that he confessed, he was damaged. He had lost his job and he lost wages. And if those promises, those false representations had not been made by the investigator, he likely would not have confessed. And that's what made the case for fraud. Investigations can generally be described in 2 different categories. We have those conducted in the public sector and those conducted in the private sector. While there are overlaps in some areas of the 2, they do differ quite a bit in both purpose, acceptable practices, as well as terminology. Public sector investigations are conducted pursuant to the enforcement of public law. So this is the police officers conducting their investigations for violations of criminal law. Private sector investigations is where most of us who are on this webinar sit. These are the investigations that are conducted pursuant to the needs of the organization. This is corporate investigations. So what are some obligations that an employer has in the private sector that may not apply to the public sector? Well, as a private sector investigation, we do want to consider some other obligations, such as moral or ethical obligations to our community as well as to our employees. As a private employer, you do have some statutory obligations that you need to think about, whether that falls under OSHA, EEOC, whistleblower statutes, anything that requires a duty to investigate in a certain manner. And there's also fiduciary responsibilities to shareholders. So as private sector employees, we really do have to think about a lot more stuff. We have a lot more hands in the pot and a lot more people to answer to. Some examples of the different terminology, which does kind of set the scene between private sector and public sector. In the private sector, we generally refer to the person we believe is engaged in the behavior as a subject. We consider ourselves as investigators fact finders. We interview the subjects about employee misconduct and attempt to obtain some kind of admission. On the other hand, the public sector is often investigating a suspect. They're interrogating the suspect that they believe committed a crime and are trying to receive a confession. So even just listening to the way that I said those, the public sector terms come across a little bit more harsh, and they do incite particular images or examples when you hear those words like suspect, interrogation, confession, versus our interviews or our admissions. So even just in the way that we explain things to our interviewees is going to influence how it comes across. Knowing false imprisonment and fraud claims are out there is important, but how are we going to combat them? One way to combat them is to have some kind of element of due process rights in our corporate investigations. Due process rights, or more accurately, the right to due process, is actually a collection of constitutional guarantees that were designed to protect citizens against abuses by the government. While legally these rights mostly apply to the public sector, juries do like to see some element of these rights play out in internal workplace investigations. And beyond using these rights to help in litigation, an employer has an ethical obligation to approach every investigation in a fair manner and to treat all interviewees with respect and dignity. So applying some element of these due process rights in your investigations will help support in that effort. On this slide, I have the three main warnings that apply to investigations. I'm just going to quickly break down the differences. Miranda warning, I think everyone is pretty familiar with. This is only going to apply to the public sector when an individual is actually under arrest and in some kind of custodial interview. I think we all have watched enough Law & Order that we can probably recite the Miranda warnings on our own. Right to remain silent. Anything you say can and will be used against you. Right to an attorney. If you cannot afford that one will be provided for you. So pretty basic stuff there, not applying to us folks in any kind of private sector. Garrity is an interesting warning that is an overlap with the public sector, but could apply to a private sector investigator. The point of Garrity is to protect employees from being compelled to incriminate themselves. Garrity applies to public employees. So these are the individuals that are employed by the government. So it doesn't matter if it's federal, local, state, city, anyone who's a government employee, the Garrity warning will apply. An example of what a Garrity warning would include is you are being questioned as part of an administrative investigation. You'll be asked questions related to the performance of your duties. You are entitled to all the rights and privileges guaranteed by laws, including the right not to incriminate yourself. If you refuse to answer questions relating to the performance of your duties, you can be subjected to disciplinary charges, which may result in your termination. However, under Garrity, if you do provide any information or evidence that could incriminate you on some criminal charges, those statements or that evidence cannot be used against you in a subsequent criminal proceedings. So it protects you from then being charged criminally. However, any of those statements that you do make can be used against you in any kind of departmental charges. Now, the right to have counsel under Garrity varies by state. So if you are conducting investigations and are interviewing government employees, make sure you know, based on the state you're in, whether or not Garrity is going to be open up to allowing them to have a right of counsel. Lastly, and the one that probably applies to most of the people on this webinar, is Weingarten. So Weingarten applies to private sector, specifically those people who are members of a union or some kind of bargaining union. Weingarten states that an employee has a right to a union representation during an interview that may result in disciplinary action. Now, technically, with the only exception here being the state of Michigan, An employee does not have to be warned about their wine garden rights. However, we think it is best practice to always put it out there. Again, we just want to be fair in our process. We want to be upfront in what our goal is in an investigation. So when we're interviewing a union employee, it is always our practice at the beginning of the conversation to let them know that they have a right to union representation during the interview, and they can choose whether or not they want to have that person present. While they have a right to have a representation there, they do not have a right to choose who that person is. So it just has to be a member of the union that holds a particular position, is not necessarily an attorney, and the individual cannot use that as a delay tactic to try and delay the investigation. If they want our union rep present, then you just get a union rep, whoever's available, and have them be present during that interview. Now I want to talk a little bit about the REID technique. The REID technique is a well-known approach to conducting investigations, and the method was developed originally for police interrogations and has now gained popularity in the private sector. Since its use began, psychologists and lawyers both have had concern that the techniques could prompt people to confess falsely. Now the REID technique is just one approach to investigating workplace issues. In my opinion and brief exposure to the REID technique, I do think that it is a harsh approach and may not always support the values and ethics of organizational cultures. Now, I'm not an expert in the REID technique, so please understand that there are many organizations that have developed their own process based on this technique and have been successful without any litigation. But today I'm going to highlight some of the techniques that REID teaches that have actually gotten organizations into trouble, as I outlined earlier in the discussed court cases. So a couple of things you got here on the slide that people complained about, and in fact the courts did determine take place. It's recommended that they take the individual to an isolated place to be interviewed, clearly leading to false imprisonment claims. It is recommended that they make small talk to build rapport. While that's something that we also recommend and is a crucial part of an interview, it's important to have parameters on what kind of small talk you can engage in. They're also taught to draw conclusions based on answers to standard questions and nonverbal cues. So basically they're taught deception techniques throughout their course. Now REID usually has anywhere from a 1 to 4 day training course, and while they do a good job of explaining how to detect deception, there's no way after taking a 4 day course people are going to be qualified to detect deception looking at nonverbal cues. So you have to be very, very careful if you're trying to apply those standards. They also teach to tell the subject that you know they're guilty and to repeatedly brush aside any denials. They encourage the use of props, even if those props are exaggerated or falsified evidence. So, for example, Chris Polson talked about the fact that the investigator said he had a DVD and physically had a DVD there, but the belief is that there was actually nothing on that DVD to prove theft. They teach bringing in a very hefty case file that is even full of blank pieces of paper to try to suggest to the individual that you've done maybe more investigation or have more evidence against them than you really do. Lastly, once a confession is received, the investigation generally stops under the REID technique. Their goal is to get that confession, and then they immediately make their decision and move on to the next issue. Convercent's approach differs quite a bit from REID. There is a little bit of overlap, but in general, our approach is to encourage organizations to keep their employees engaged by using process and technology. Technology can really help you communicate with your employees and manage your processes so that you can spend less time putting out fires and more time endorsing your company ethics and values. Convercent's process of investigation is a proprietary method that was developed by our Chief Ethics Officer, Eugene Ferraro. It is a phasal approach that unfolds incrementally and is documented throughout the process to ensure consistency and an affirmative defense in the case of litigation. Convercent's process of investigation takes an investigator from the first step of an investigation, the assessment phase, walks them through the fact-finding process and decision-making, and ends up with education and training to ensure that similar incidents do not happen again in the future. I want to spend a minute here explaining how Convercent recommends investigators approach some of the issues that we highlighted in the previously discussed litigation cases. So Convercent's phase-based approach allows us to follow consistently in every incident, no matter if you have a claim of theft or you have a claim of harassment. The approach is dynamic enough that you can switch it up and address the issue effectively. Our process allows for full due diligence in our fact-finding process. We often spend hours and the bulk of our time gathering information at the beginning of an investigation before we get into the interview with that individual we believe engaged in the wrongdoing. Excuse me. When we get into that room, we are 95% sure that that individual has engaged in the behavior because we have consistent information where all the arrows point that way. This approach also allows for follow-up and closing the loop. So once we obtain an admission, we do not stop our investigation there. We understand that there could be mitigating or extenuating circumstances that affect the admission. For example, in the case of Chris Polson, where he acknowledged taking a candy bar and soda, it turns out that his manager actually gave him authorization to take those. So had there been any kind of follow-up, any kind of questioning as to why you took it or why you thought you could, or interviewing of the manager to see if he was aware that Chris had taken that, a decision was made. So following our process, we're going to ask the whys. There could be some kind of systemic situation that is causing the person to engage in the behavior. And if you don't ask the why, you're never going to find it out, and you're going to continue to have the same issues arise. So it is important to have follow-up, and just because you get an admission is not the end-all, be-all. We want to ask additional questions. Convercent's approach to avoiding false imprisonment, we have some very specific ideas around where the room should be located and how you're going to actually set up the location of the room to lessen the likelihood of a false imprisonment claim. So you can do it in any kind of room. We recommend that the room be neutral if at all possible, so some kind of neutral conference room, and basically only has to have a table and 2 chairs. We do recommend that you put the subject's chair closest to the door and that there be no obstruction between them and the door so they have free access to leave. We even go a step further. The process is voluntary, and we make a disclosure as to that at the beginning of our conversation, the beginning of our interview. We explain to the individual that this is a voluntary process, and if at any time they need to take a break or would like to discontinue the process, they absolutely have that right to do so. We also force breaks. So if we've been in the room for about an hour, hour and a half, if the individual didn't ask for a break, I'll let them know that I need a break. I'm going to write down in my notes that we took a break and that the individual then came back. So this shows to the courts that the person did have an opportunity to leave and voluntarily chose to come back in the interview. As far as the voluntary process disclosure, some people ask or are hesitant to tell people at the beginning of an interview that it is a voluntary process because they think they're just not going to talk to them. And I can tell you, majority of the time, that person is curious to know what you know, and they are going to stay in that room. In the 7.5 years I've been conducting these investigations, I've conducted hundreds of investigations, and only on one occasion have I ever had someone take me up on leaving the room based on that voluntary disclosure. So it doesn't necessarily incite what you think it may, and it sets a very good tone of having a fair and impartial interview. The rapport building techniques we think are really good to do, but you want to keep it relevant. So you should not be asking the person about their personal life, about their children. We want to keep those questions more job related. So how long have you been working here? What do you like most about your job? What are some things that you think the organization could improve? These are benign questions that are going to help you build rapport with the individual without getting in a sticky situation where you're asking about personal questions. You also want to set the theme of the conversation. So you need to prepare some kind of theme that you can present to the individual. We don't want to try and fool them. We don't want them to think that they're helping us out when in fact we're going to accuse them of something. So the theme is going to be some kind of monologue that you present, and it will offer a rationale for both the investigation as well as for the actions of the subject. Your theme should never absolve the subject of any legal consequences for your actions. While you can reveal some information about the offense, you don't want to reveal key information or key evidence, and you never want to embellish the strength or amount of evidence that you have. So basically, you just kind of want to set the tone. Let them know that the organization has policies that address inappropriate behavior or misconduct. Explain to them that some time ago a complaint did come in that the policy had potentially been violated, that you have conducted an investigation, you've conducted fact-finding efforts and interviewed individuals. As a result of that investigation, you are having a conversation with them and want to hear their side of the story. So you're really setting it up that you're making it very clear to the individual that there is concern about a policy violation, and this is their opportunity to tell their side of the story. Lastly, we never want to threaten or coerce anyone or make any promises. As an investigator, you should not also be having the role of decision maker. So you're in a position where you shouldn't be able to make promises because you don't know whether they're going to be able to keep their job or whether the company's going to turn it over to the police. So never make any of those promises that you can't keep. We like to use this ethics test. So this is very easy to apply when you're questioning whether or not a technique should be used in a corporate investigation. Ask these 5 questions every time you even have a hint of doubt. No one of these questions is any more important than the other. Oftentimes, when I'm going through these questions, I'll find that it can, that it meets the ethics test of number 1 through 4. But then you get to number 5. Is it consistent with our organizational values? That takes it to a whole nother moral and ethical level. And it is very important that you're conducting yourself consistently with those organizational values. Just have a couple of parting words here and lessons learned from my review of these court cases and kind of looking at the different techniques that have been played out by investigators across a variety of industries. We must always uphold the integrity of the investigation process, not only while we're talking to the individual, but before as we're working up to the investigation as well as after the investigation. We are corporate investigators and above all must treat every person with dignity and respect. I don't care how much money they stole, I don't care who they harassed. Every person has the right to be treated with dignity and respect throughout this process. As an investigator, it is one of the most rewarding things to have interviewed somebody, have them admit to a behavior, and know that they're going to lose their job as a result of that admission. But at the end of that interview, they're able to stand up, shake your hand, and say, I understand that I did something wrong, but I appreciate the way you treated me throughout this process. It really goes a long way. You try to strong-arm someone, you're probably going to get that right back at you. Remember that we're never playing gotcha, which means while we do want to eliminate potential bad employees who are violating policy, we're not always going to catch the bad guys. But at the end of the day, we do always want to be able to look at ourselves in the mirror and know that you upheld the company's values and ethics. So we do have some resources available for you guys. If you're interested in a little bit more information, a little more in depth on how to conduct investigations into workplace incidents, you can check out this link. I briefly mentioned some technology earlier in the webinar. Convercent does have case manager technology, has full hotline and incident management, reporting and auditing capabilities, as well as policy and education modules. We do believe that the use of this kind of technology and consistent documentation during an investigation as well as with policies and education can help your company have an affirmative defense in the unfortunate case that you are in litigation. If you'd like any more information about our case management system or any additional resources, please check out our website at convercent.com. So that's about it. We're coming up to the end of the webinar. If you found today's topic and content interesting at all, you can follow me on Twitter at autumn8141 and check out our website for some upcoming webinars. Before we sign off, it looks like we've got about 5 minutes left, so I want to open it up to any questions. We do have several questions that were submitted throughout the webinar, so I'm going to address those. But if you held your questions, now would be a great time to go ahead and get them in. So, okay, the question is there a length of interview time that constitutes false imprisonment? No, there is no specific time that if you go beyond this, it now becomes an issue. What you need to do is read the person. Generally speaking, an hour to an hour and a half is going to be a safe time frame. Now, if you have someone that's particularly fidgety, clearly if they ask for a break, we definitely want to accommodate that. But if they are, you know, really thirsty and you don't have any water in there, I mean, watch their demeanor. And if they're, you know, you can force a break based on how they're behaving. But like I said, we generally, rule of thumb, go about the hour and a half mark. You do not want to be going over 2 hours, keeping that person in the room without a break. Okay, cool. Is there any warning you recommend for private sector with no bargaining unions? Yes. So every company is going to tackle this differently. Again, it depends on what your policies and procedures are. We go through initial disclosures at the beginning of our conversation, which can be referred to as warnings. So what we do is we explain to them what confidentiality means, how we're able to keep the conversation confidential, and what any exceptions to that confidentiality may be as far as a need to know. We explain to them about the voluntary process, which is a good warning to have. Now, some companies have a policy that requires participation. So either a manager is required to participate, or sometimes all employees are required to participate in internal investigations. If they don't, they could be subjected to disciplinary action. So while this is a warning that if your company has a policy about it is important, we tend to stay away from making that warning right at the beginning of the conversation because it could be interpreted as threatening. So what we do is we allow the person the opportunity to participate. If they get at some point during the conversation where they don't want to participate anymore or they want to leave, we explain that they absolutely have that right to do so, but we do want to make clear that the company has a policy, and if they choose not to participate, they could be subjected to disciplinary action. Now, if someone is questioning whether or not they want to leave that interview, let them know about your policy. If they decide they then want to stay, definitely force a break at that point. Tell them to take a break, go to the bathroom, think about it, and then if they voluntarily come back in that room, then continue the conversation. What are the legal and ethical considerations for recording interviews? This is probably the last one we have time for. So as far as recording, the main legal issue is whether or not you're in a one-party or two-party state, meaning whether or not you have to tell the individual that you are recording the conversation. I would never recommend, even if you are in a one-party state, I would never recommend recording a conversation without someone's knowledge. Always best ethical practice to let them know that you are recording the conversation. We tend to not record the conversations. It sets a certain tone at the beginning of the conversation. We're taking notes, so in that aspect, you know, we're physically recording with notes, but we don't want them to record the conversation, so it's kind of a two-way street. Now, if we do get an admission, we may record that part of the conversation just to really get that set in stone. So after they admit to the behavior, after we get through the end of our interview, we then say, okay, we would like to actually record what you shared with me. Let's go over that, and then you could put on the recorder. As far as ethically, again, as long as you're making it known that you're recording it, you're going to be good to go. I think that is about all that we have time for. We're up on the 45-minute mark. So we had a lot of good questions here, and hopefully we got to answer them all. If you have any other questions, again, look at our website, shoot us an email. We'd be happy to follow up and answer anything that we can. And please do check out our website for other information and upcoming webinars. Thank you for your time today, and have a great day.